President Trump addressing the alleged retribution against his political opponents in his first CBS interview since the Bari Weiss takeover and since settling a lawsuit with the network.
James Comey, John Bolton, Letitia James were all recently indicted. There's a pattern to these names. They're all public figures who have publicly denounced you. Is it political retribution?
You know what? You know who got indicted? The man you're looking at. I got indicted, and I was innocent.
Did you instruct the Department of Justice to go after them?
Not in any way, shape, or form. No, you don't have to instruct them because they were so dirty, they were so crooked, they were so corrupt.
News contributor Joe Concha joins us now. Joe, good morning. What were your top takeaways from this interview?
Good morning. Oh, well, I think the president is correct here, Carly. It's not about retribution. It's about those 6 words we heard over and over again when it came to President Trump. No one is above the law. So whether we're talking about James Comey or John Bolton or Letitia James, the question is, did they break the law and be held accountable?
What's happening, folks? Dr. John here. So this is happening right now. A judge has ordered Trump to sit for sworn testimony in a fraud investigation, and every last-minute delay tactic his lawyers threw at the court has been decisively rejected. The ruling forces Trump to directly address allegations that he directed over a decade of inflated business valuations, under oath, with documentary evidence ready to contradict any false answers. Think about the position Trump finds himself in right now. The man who has spent decades making outrageous claims about his wealth, who has told the public that his net worth varies by billions of dollars depending on how he feels on any given day, who has made statements so contradictory that even his own accountants eventually resigned and said they couldn't trust the financial information they were given, now has to sit in a room with lawyers and answer specific questions about specific properties under the penalty of perjury.
Now, from a media standpoint, it is telling that the president did decide to go back on 60 Minutes, something like 5 years after the last time he did that. And that is the Bari Weiss effect in terms of righting the ship and over there because it's gone so far to the left, and so biased towards anybody remotely conservative. Maybe we can make it Mike Wallace's 60 Minutes again. That's the hope here. And you watched that interview last night and I thought the questions were fair, and it was like watching your daddy's 60 Minutes again, and that's a good thing.
And I also think it was very important, the time slot. They had a very good lead-in with the Chiefs-Bills game, a lot of eyeballs on that, gave the president a major opportunity to get his message out there. And also, like you said, with Norah O'Donnell asking actual legitimate questions, I think it was a win for everybody involved. Speaking of winning, Kamala Harris did not. And now George Clooney is defending his 2024 op-ed, calling for former President Biden to withdraw for the race, but he's also criticizing Democrats' quote-unquote mistake with Kamala Harris. Clooney saying, quote,
"This is the kind of situation that legal experts have been warning about for years, the kind of situation that Trump has been trying to avoid through every legal maneuver available to him. And now it's happening, whether he likes it or not. Let me walk you through exactly what this order means, because the implications for Trump are extraordinarily serious when you consider his documented relationship with truth and his demonstrated inability to tell consistent stories about his finances. The judge didn't just order Trump to testify in general terms. The order specifically focuses on asset inflations, including the tripling of Trump Tower values that formed a central allegation in the fraud case. We're talking about specific properties, specific valuations, and specific claims that Trump made that don't match up with reality. The order requires Trump to address these issues directly and provide answers that will be compared against the documentary evidence that investigators have assembled.
I think the mistake with it being Kamala is she had to run against her own record. It's very hard to do. If the point of running is to say that I'm not that person, it's hard to do. And so she was given a very tough task. I think it was a mistake, quite honestly, but we are where we are. I'll ask you the same question, Joe, I asked you in July 2024. Why does an actor feel like he should have an outsized role in picking the president more so than any single voter?
That's the amazing thing, right? I mean, it was George Clooney that right after that 2024 debate wrote that op-ed. I believe it was in the Washington Times, maybe New York Times, or Washington Post, I should say, and said that Joe Biden should drop out. And that had more of an impact in that happening than any Democrat lawmaker coming forward and saying that. So, yeah, obviously, Clooney's right. It was a mistake to have Kamala Harris in there as far as being the installed candidate. Democrats should have had an open primary and actually have voters weigh in from the Democrat side in terms of picking who the candidate was.
And here's something that really tells you how serious this situation has become. Trump's own lawyers had to admit potential obstruction and evidence issues during the proceedings. Think about that for a moment. When your own attorneys are standing in court acknowledging problems with obstruction and evidence, that's not a sign that things are going well. That's a signal that the legal situation is deteriorating rapidly and that the defense team can no longer credibly deny problems that the court can plainly see. The fraud allegations themselves are staggering in their scope and scale. We're talking about billions of dollars in overstated net worth spanning from 2011 to 2021. The Attorney General, Letitia James, is seeking $250 million in fines and comprehensive business bans that would effectively shut down Trump's ability to operate in New York. This is the case that eventually produced the massive fraud judgment that's now threatening Trump's empire with asset seizure.
Instead of going Soviet style the way they did with Kamala Harris, because all she did was lose the popular vote. Every swing state gave back the Senate to Republicans, and they held the House. So overall, the worst $1.5 billion investment we have seen in political history. That is for certain. But George Clooney, again, apparently has a lot of sway within the Democrat Party, despite not having like a real big hit since Ocean's 11, which came out, I think it was about 25 years ago.
It was a good movie, though.
Excellent movie.
I mean,
Danny Ocean.
You can't just take that away from him. Do you think that his opinion now has any sway over the 2028 race if Kamala Harris jumps in then? Are we so far from that it doesn't really matter?
No, that's true. I think, honestly, Carly, if Kamala Harris runs, if she runs for 2028 as far as being president, she won't get to 2028. She's never earned a vote in her life as far as running for president. So I could see more of an AOC or a Gavin Newsom being the nominee, which that's not going to go well if that's the case, because you have to win in places like Pennsylvania and Wisconsin, North Carolina, Georgia.
And the testimony order occurred during the investigative phase, representing a critical moment where Trump was compelled to provide answers under oath about what he knew and what he directed regarding asset valuations. Now, let's really think about what it means for Trump to be ordered to testify under oath about his finances. This is someone whose financial statements were so fraudulent that his own accountants resigned and said they couldn't be trusted. This is someone who inflated his triplex apartment from 10,900 square feet to 30,000 square feet, nearly tripling it to inflate claimed value by $200 million. Now he has to answer questions under oath about all of this, with documents ready to contradict any false answers. Legal experts have been talking about the perjury trap that Trump faces in this situation, and I want to be clear about what that actually means. The term trap suggests something that's been set up to catch someone off guard, but that's not really what's happening here. The perjury exposure isn't a trap in the traditional sense. It's simply the natural consequence of someone who lies habitually being forced to testify under oath. If Trump tells the truth, he admits to directing fraud. He admits that he personally instructed employees to inflate values or that he approved inflated values that others suggested. If Trump lies, he commits perjury and faces criminal exposure that goes beyond the civil fraud case. There's no middle path where he can spin his way to a favorable outcome. The choice is between confession and additional crime. And for Trump, neither option is acceptable. That's the real dilemma he faces. Trump's lawyers have tried every delay tactic you can imagine. They've filed appeals. They've sought postponements. They've raised procedural objections. They've claimed executive privilege. They've asserted constitutional protections. Each and every argument has been rejected by courts that recognize what the delays are designed to accomplish. They're trying to prevent Trump from ever having to answer questions under oath about conduct that documentary evidence clearly documents. The judge's rejection of the last-minute appeal signals that these tactics have run their course. The courts have seen enough of the delay games, and they're not going to allow them to continue. The risk of contempt charges if Trump refuses to comply adds another dimension to his exposure. Courts enforce subpoenas through contempt power, fines, and potentially imprisonment until compliance. Now, jailing a sitting president would create unprecedented constitutional complications. I'll grant you that. But the court has tools to enforce its orders, and contempt adds to the narrative of Trump as someone who believes rules don't apply to him, who will defy courts rather than answer legitimate questions about proven fraud. The Fifth Amendment option that Trump could invoke, refusing to answer on grounds of self-incrimination, carries its own costs in civil proceedings. And this is something that a lot of people don't fully understand. Unlike criminal cases where invoking the Fifth cannot be used against you, civil proceedings allow judges and juries to draw adverse inferences from Fifth Amendment invocations. If Trump refuses to answer whether he directed false valuations, the court can infer that truthful answers would be incriminating. Invoking the Fifth doesn't protect Trump in civil cases the way it would in criminal ones. The connection to the eventual fraud judgment that's now threatening Trump with asset seizure shows how this testimony order fit into the broader legal strategy that successfully held Trump accountable. The Attorney General used the testimony, along with documentary evidence and other witness statements, to build the case that produced findings of systematic fraud over more than a decade. The testimony order was a step toward the judgment that now threatens to dismantle Trump's business empire. The pattern connecting this testimony order to other cases where Trump has faced deposition requirements shows how consistently courts have rejected his claims to be above legal process. In the E. Jean Carroll defamation case, Trump was required to sit for deposition. In various civil matters over the years, Trump has been compelled to provide testimony he desperately wanted to avoid. Each time his lawyers raised objections and sought delays, each time courts eventually ordered compliance. The fraud case testimony order fits this pattern of courts concluding that Trump must answer questions like anyone else facing legitimate legal proceedings. So let's really break down what the testimony order required and why courts rejected Trump's appeals. We need to look at the specific issues Trump was ordered to address and why truthful answers are so problematic for him. We need to examine the perjury and contempt risks that make sworn testimony so dangerous for someone with Trump's relationship to truth. And we need to discuss how this compelled testimony contributed to the eventual judgment that now threatens his empire. Let's get into the specific details of the testimony order, what questions Trump was required to answer, and why compelled testimony is so uniquely dangerous for someone whose public statements about his finances have been demonstrably inconsistent and often false. The order compelling Trump's testimony came in the context of the Attorney General's civil investigation into Trump Organization financial practices. The investigation had been examining whether Trump and his company systematically inflated asset values on financial statements used to obtain loans and other benefits. The Attorney General had authority to compel testimony as part of the civil investigation, and Trump's legal team had been fighting that authority through every available procedural mechanism. The specific focus of the testimony included Trump's role in directing asset valuations, whether he personally instructed employees to inflate values or approved inflated values others suggested. The triplex apartment issue was particularly significant. Someone had told accountants the apartment was 30,000 square feet when it was actually 10,900. Who made that decision? Did Trump know? Did he approve? These are questions that can only be answered through testimony from people with direct knowledge, and Trump was the ultimate decision maker in his organization. The rejection of Trump's last-minute appeal followed a long pattern of delay attempts. Trump's lawyers had sought postponements, claiming various procedural defects, constitutional protections, and scheduling conflicts. Each attempt bought time, but didn't change the underlying legal situation. Courts have wide discretion to compel testimony in civil investigations, and the grounds for refusing to comply are limited. Trump's objections were creative, but ultimately unsuccessful. The admission by Trump's lawyers that there were potential obstruction and evidence issues signals how seriously the legal situation had deteriorated. Lawyers don't casually acknowledge obstruction problems. Such admissions invite additional legal scrutiny and potential sanctions. The acknowledgement suggests the court had identified problems with how Trump and his team had handled discovery and document production, problems serious enough that lawyers felt compelled to address them openly rather than continue denying issues the court could see. The deposition format for testimony creates particular challenges for Trump's communication style. In depositions, questions are asked one at a time and must be answered directly. Lawyers for the opposing side control the questioning and can follow up on evasive or incomplete answers. Unlike press conferences or interviews where Trump can deflect, change the subject, or simply talk over questioners, depositions require specific responses to specific questions. Objections can be raised, but legitimate questions must eventually be answered. Trump's historical statements about his net worth create landmines throughout any financial testimony. He is claimed to be worth $10 billion in some contexts and dramatically less in others. He has said his net worth varies based on his feelings about it. He has made specific claims about property values that documentary evidence contradicts. Every prior statement is potential impeachment material. If Trump testifies to something inconsistent with his prior claims, questioners can confront him with the contradiction and force him to explain which version was false and why. The documentary evidence assembled during the investigation makes evasion extremely difficult. Financial statements exist showing specific claimed values. Internal documents may show how those values were determined. Emails and communications may reveal who directed what. Accountant files before Mazars resigned show what information the Trump Organization provided. Trump can't simply deny things that documents prove happened. He can only try to explain his role in ways that minimize his responsibility. The perjury exposure is genuine because false statements under oath in official proceedings constitute criminal conduct. Perjury requires proof that the witness knew their statement was false and made it anyway. The documentary evidence in the fraud case provides exactly the kind of proof that would support perjury charges. If Trump testifies that he didn't direct inflated valuations and documents show he did, prosecutors have the elements they need. The Fifth Amendment option deserves detailed examination because it's Trump's only way to avoid answering without lying. The Fifth Amendment protects against compelled self-incrimination. You can't be forced to provide testimony that would incriminate you in criminal conduct. Trump could invoke the Fifth in response to questions where truthful answers would admit to crimes. But in civil proceedings, the trier of fact can draw adverse inferences from such invocations. If the question is, did you direct employees to inflate asset values, and Trump invokes the Fifth, the court can infer that the truthful answer is yes. Trump actually did invoke the Fifth Amendment extensively in his deposition, reportedly over 400 times. This strategy avoided the immediate perjury risk, but allowed the court to draw adverse inferences on every question where he refused to answer. The extensive Fifth Amendment invocation itself became evidence of consciousness of guilt. An innocent person would simply deny wrongdoing. Invoking the Fifth suggests truthful answers would be incriminating. The eventual fraud judgment that resulted from the investigation, including the testimony, confirms that the legal strategy of compelling testimony and drawing adverse inferences was successful. The judge found Trump liable for persistent fraud over more than a decade. The appellate court unanimously affirmed the fraud findings. The evidence developed through the investigation, including whatever testimony was obtained and whatever inferences were drawn from Fifth Amendment invocations, supported comprehensive findings of systematic deception. The contempt option for non-compliance represents the court's enforcement mechanism. Courts compel testimony through subpoena power, and defiance of subpoenas can result in contempt findings. Civil contempt typically involves fines or imprisonment until the witness complies. The contempt can be purged by finally answering the question. Criminal contempt punishes the defiance itself and can result in fixed sentences regardless of subsequent compliance. For a sitting president, contempt enforcement would create unprecedented constitutional complications. No court has ever held a sitting president in contempt or attempted to imprison one for defiance. But the threat of contempt and the political damage from defying judicial orders provides incentive for compliance even when direct enforcement might be constitutionally problematic. Trump ultimately participated in the deposition despite his objections, suggesting the contempt threat had effect. The pattern across Trump's legal matters shows consistent judicial conclusions that he's not above normal legal process. In the Carroll case, he was required to sit for deposition and did. In the fraud investigation, he was required to provide testimony. In various other civil matters, courts have compelled his participation. The consistent pattern is that Trump's objections, however creatively argued, don't ultimately exempt him from legal processes that apply to everyone else. The legal team's position throughout these proceedings revealed the fundamental dilemma they faced. Advising Trump required navigating between his insistence on delay and the reality that courts would eventually compel compliance. Acknowledging obstruction and evidence issues, as occurred in the coverage, suggests lawyers concluded they could no longer credibly deny problems the court could plainly see. The legal representation of Trump has always required navigating his unrealistic expectations and his tendency to blame lawyers when his preferred outcomes don't materialize. Let's break this down into what everyone needs to understand, because this testimony order represents a critical moment in Trump's fraud accountability, where his options narrowed to confession, perjury, or extensive Fifth Amendment invocation, none of which were good. The judge rejected Trump's last-minute appeals and ordered sworn testimony specifically addressing allegations that he directed inflation of asset values, forcing him to answer questions under oath where every statement could be contradicted by documentary evidence and prior inconsistent statements. Trump's lawyers admitted potential obstruction and evidence issues during the proceedings, signaling serious problems with how the defense had handled discovery and document production that prompted the judge to demand direct answers under oath. The perjury trap Trump faced wasn't really a trap at all, but the natural consequence of someone who lies habitually being forced to testify under penalty of perjury, where truthful answers admit to fraud and false answers constitute additional crimes. Trump's extensive Fifth Amendment invocations during his eventual testimony allowed the court to draw adverse inferences on every question he refused to answer, effectively treating the refusals as admissions of guilt that supported the eventual fraud findings. The testimony contributed to the comprehensive fraud judgment that now threatens Trump's empire with asset seizure, demonstrating that compelled testimony served its purpose of developing evidence that held Trump accountable. The significance of a sitting president being ordered to testify under oath cannot be overstated for understanding the legal situation Trump faces. The presidency provides no exemption from civil legal process, a principle established in Clinton versus Jones and repeatedly confirmed since. Trump cannot simply refuse to participate in legitimate legal proceedings because he holds high office. The presidency is not a shield against accountability for private conduct. The documentary evidence problem makes Trump's testimony particularly dangerous because so much of what he has said publicly can be compared to what documents show. His financial statements claimed specific values. His prior statements asserted specific net worths. Internal communications may show specific instructions. When testimony is compared against this documentary record, inconsistencies become apparent immediately. Trump can't spin his way out of contradictions that exist in black and white. The Mazar's resignation amplifies the problem because Trump's own accountants have said the financial statements can't be trusted. When the people who prepared the documents say they're unreliable, Trump can't blame the accountants or claim he relied on their professional judgment. The Mazar's resignation removed a potential defense and focused attention on the Trump organization itself as the source of false information. The Fifth Amendment invocation strategy, reportedly used over 400 times, tells its own story about what truthful answers would reveal. Innocent defendants don't invoke the Fifth hundreds of times because they have nothing to hide. The extensive invocations signal that truthful answers would be incriminating on question after question. In civil cases where adverse inferences are permitted, this strategy essentially concedes the underlying allegations while avoiding perjury. The contempt risk for refusal to comply shows how courts can enforce their orders even against powerful defendants. While direct imprisonment of a sitting president would create unprecedented complications, the threat of contempt with its escalating sanctions provides meaningful incentive for compliance. Trump's ultimate participation in the deposition, despite vigorous objections, suggests the contempt threat influenced the decision for the eventual fraud judgment. The testimony or the adverse inferences drawn from Fifth Amendment invocations contributed to findings that Trump was liable for systematic fraud. The court had a complete picture: documentary evidence of false valuations, testimony or refusals that confirmed Trump's involvement, and the Mazar's resignation confirming the accountant's conclusion that the statements were unreliable. The judgment followed logically from this comprehensive evidence. The implications connect to the broader narrative of Trump's legal accountability. He invoked the Fifth over 400 times as a fact that Democrats can use to argue Trump had something to hide. The testimony order and its aftermath are part of the comprehensive record showing Trump's fraud was investigated, proven, and affirmed on appeal. This record supports campaign messaging about Trump's fundamental dishonesty. The impeachment connection exists because perjury and obstruction are both impeachable offenses. The acknowledgement of obstruction issues during the testimony proceedings, the extensive Fifth Amendment invocation suggesting consciousness of guilt, and the eventual fraud findings all provide material for impeachment arguments. A president whose lawyers admit obstruction problems and who invokes the Fifth hundreds of times rather than answer questions about fraud is a president whose conduct warrants congressional scrutiny. Looking at the legal team's performance, the admission of obstruction and evidence issues represents a significant moment where lawyers concluded they could no longer deny problems the court could see. Such admissions are unusual because they invite additional scrutiny. Lawyers typically avoid acknowledging problems unless the alternative, continued denial, has become untenable. The admission suggests the court had identified specific issues that required acknowledgement rather than continued resistance. The pattern connecting the fraud testimony to other compelled depositions shows how consistently Trump has faced legal process despite his objections. The Carroll deposition, the fraud investigation testimony, various other civil matters over the years. Each time Trump's lawyers raised objections, each time courts ultimately compelled compliance, the pattern confirms that Trump is not above the legal processes that apply to everyone else, regardless of what office he holds. For Trump's relationship with his legal team, compelled testimony proceedings create tension because lawyers must advise that compliance is eventually required, while clients want to hear that resistance will succeed. Trump's history of blaming lawyers when outcomes disappoint suggests these proceedings strained attorney-client relationships. The acknowledgement of problems may reflect lawyers protecting themselves as much as managing the case. That's where things stand with this testimony order that forced Trump to choose between confession, perjury, and extensive Fifth Amendment invocations that allowed adverse inferences supporting the eventual fraud judgment. The rejection of last-minute appeals that signaled delay tactics had run their course. The admission of obstruction and evidence issues by Trump's own lawyers. The perjury trap that wasn't really a trap, but just the natural consequence of compelled truthfulness. The hundreds of Fifth Amendment invocations that told their own story, and the contribution this testimony made to findings that now threaten Trump's empire. The testimony proceedings we've documented here were a crucial step toward the judgment that now threatens to dismantle Trump's business empire through asset seizure and license cancellation. The testimony or adverse inferences from refusals provided the evidence courts needed to find fraud. That finding has been affirmed. Enforcement is proceeding. And if Trump thought invoking the Fifth over 400 times would protect him, he's now facing the consequences of all those inferences courts were permitted to draw. The legal system has a way of catching up with people who believe they're above it, and we're watching that process unfold in real time. The courts have spoken, the evidence has been examined, and the judgment is now being enforced. This is what accountability looks like when you've spent years thinking you could say anything and get away with it. The bill has come due.